in Austin, Texas, and today I'm going to be presenting on transaction structuring and legal considerations for a buyer and or seller when involving the business transaction, when selling your business. So generally with this type of transaction, there'll be a purchase and sale of one of two things. One would be a sale of a company's assets that are owned by the company. Two would be a sale of the company itself. So the ownership interest, whether it's a membership interest if you're an LLC, or stock if you're a corporation, for example. So with an asset sale, you're purchasing the assets and liabilities of the business. Occasionally, some assets can be excluded from the sale and remain with the company itself, but that is something that is generally negotiated during the purchase and sale process. So seller would retain ownership of the company in this instance, and the buyer would form a new company or use an existing company to hold the assets that they are acquiring. Importantly here, the buyer in an asset sale doesn't take on the debts and liabilities and obligations of the company unless specifically agreed in the transaction itself. But so for example, the company would remain liable for any outstanding debts and liabilities and its obligations under any contracts, unless those contracts are part of the assets that you're transferring. So with a stock or ownership interest sale, the buyer purchases the stock or membership interest of the company, and along with that, the assets, the contracts, the debts and liabilities of the company are transferred to buyer. Generally, unless otherwise agreed, the seller walks away from all future liabilities of the company, which naturally makes a purchase of the company as opposed to a purchase of the company's assets riskier to the buyer than a purchase solely of the company's assets. So ultimately, every deal is different, and whether a sale of the assets or of the company itself is the right structure depends on what the parties are looking for and the characteristics of the transaction itself. So once you've found a potential buyer, and the initial steps for the parties after that usually involve developing what's called a letter of intent or a term sheet, and sometimes both. The letter of intent is exactly what it sounds like. It's for the parties to show their intent that they want to consummate the transaction and to indicate to each other really that they are serious about buying and selling the business. Sometimes the buyer will want to include an exclusivity provision in a letter of intent, or sometimes called a no-shop provision. What's good about this for the buyer is it prohibits seller from looking for other buyers while the seller and this potential buyer are negotiating the terms of the deal. An LOI can also in turn include the parties' understanding of the commercial terms of the deal, but generally note that the terms of a letter of intent with respect to commercial points are generally non-binding. With the letter of intent, there's a term sheet that is often produced in conjunction with that, and sometimes it's used as an alternative to the letter of intent, but the parties create a term sheet, which again means exactly how it sounds. It's a document that outlines the commercial terms of the deal. The benefit of a term sheet is it's a fast and convenient way for the parties to agree upon the material terms of the transaction. Now, how detailed the term sheet is depends on the transaction and the party's preference. I'll note this is the time that you should get your accountants and other advisors, your attorneys involved to weigh in on the key terms of the deal to avoid missing any material issues or unfavorable terms to you that you might have not otherwise picked up on. And I say this because once the LOI and the term sheets are agreed upon and negotiated, each party expects the other party to stick to the terms of those documents, regardless of the fact that they are non-binding. Unless once you go through the diligence process, there's issues that are revealed that materially change the terms of the deal or the understanding of the parties. One other document that you'll see in some of these transactions is a non-disclosure agreement, and this is usually in favor of the seller, and it's an agreement to not disclose any information that's learned during the transaction or negotiation process. And this is generally a good idea for a seller, especially if their company has certain company secrets or intellectual property or other matters that the seller wants to protect from being disclosed in the event that the transaction doesn't actually come to fruition. So after the LOI and term sheets are finalized, as I hinted to in my previous response, the diligence process kicks off in full force. So during this process, the seller will provide to the buyer all of its contracts and property documents, for example, purchase orders, financial data, and other relevant information. And this is the time where the buyer has the chance to identify the risks and liabilities of the company or the assets that they are purchasing. So any buyer needs to be sure to conduct thorough diligence and discover any material information that otherwise was not previously disclosed or omitted, whether intentional or not, early on in the negotiation process. And this will avoid surprises and unknown liabilities after the acquisition, so down the road, when you don't have the chance to mitigate those liabilities. So in the event that issues are uncovered during the process, the parties can come up with various different ways to mitigate the risks. For example, through a reduction in the purchase price, carving out from the deal problematic assets, or other restructuring concepts to account for those risks. And some types of issues to look out for during the diligence process are legal issues, financial and security matters, operational issues, which include employee matters, intellectual property issues, understanding the obligations and liabilities in existing contracts of the company that you would be taking over, and other matters depending on the nature of the business, whether it's property matters or environmental and insurance matters. So there are a lot of things to look out for, and sometimes they are customized to the type of business that you're purchasing. So coincidental with the diligence process, so while that's going on, the parties will begin putting together the terms of the LOI and term sheet into a formal agreement, which is the purchase and sale agreement. This is the document where the parties set forth their rights and obligations with respect to the transaction. So material issues to consider when drafting and negotiating the terms of the purchase agreement are how the purchase price and purchase price payments should be structured. For example, it could be one lump sum payment that's paid at closing or shortly thereafter. Or other situations call for payments to be made in installments or upon the occurrence of certain future events. What may come with the latter situation is creating what's called a deferred closing structure, which requires certain conditions to be satisfied before the parties are required to close the transaction. So this provides, the benefit of this for a buyer is it provides them with certain protections in the event that those future events or conditions don't in fact occur. It gives them an out. So other besides the purchase price structure, other key provisions are the representations and warranties that the parties are making. This section includes statements by both parties with respect to material facts in connection with the transaction. So, for example, that each party has the authority to enter into the transaction and has received the necessary internal approvals to consummate it. Other important seller representations include that the seller owns good title to the assets of the company, that there are no pending actions or claims against the company unless otherwise disclosed, and that entering into the transaction doesn't require additional third-party approvals or will cause any breach of an existing contract that's in place between the company and another party. So the key here is a breach of a rep or a misrepresentation of any of these provisions generally means the transaction can be terminated and the non-breaching party can sue the other party for breach. So other important terms of the purchase agreement include setting out what the assets and liabilities will be part of the transaction, addressing tax implications and allocations, and what, as I mentioned before, what matters need to be satisfied or achieved in order for the closing to occur. One point I do want to make is there are certain provisions that are often overlooked, which they shouldn't be, because these are the types of provisions that can hurt a buyer or seller down the road. And just as an example, making sure you understand the dispute resolution process, whether it'll be through arbitration or whether one party can bring another party to court. Another one is the indemnification provisions in the agreement. So in the event that there is a breach of the agreement, whether there are any indemnity caps, so whether how much a party can receive as a result of the other party's breach is capped at a certain amount, and whether some representations or warranties may not apply to the indemnification provisions, for example. So those are some of the very important provisions to make sure to include in a purchase agreement, but also be on the lookout for and make sure they have terms that are favorable to you. So the closing process, it can be different depending on the type of transaction, but generally the best way to approach a closing is to create a closing checklist. Now this helps the parties prepare for the closing and make sure they have all the documents they need and all the conditions have been satisfied in order to achieve the closing. So this includes, like I said, the documents, agreements, whether there are any regulatory filings that need to be made. With that, you then have a group of ancillary documents that generally need to be completed. And while it depends on the type of transaction in the payment structure, some of these ancillary documents include a bill of sale or membership interest assignment agreement, assignments of any leases and contracts in the case that it's an asset sale, and then potentially consent to assignment of these contracts from the counterparties. They need to agree to that assignment, depending on what the assignment provisions are in that particular contract. Another item is assignment of any intellectual property. So in all transactions, there should be a requirement for an officer certificate, which certifies that the representations and warranties of that company are true and correct as of the closing date. Another document that should be provided is a consent and authorization from the governing body of the particular party involved, and as well as shareholders or members of the parties. And I should also mention if there are any encumbrances or liens on the company or its assets, generally you should try to receive evidence of release of those liens or encumbrances. So logistics of the closing On the closing day, the parties will meet in person to sign the purchase agreement and any other ancillary documents that need to be signed at closing. Or nowadays, often closings can occur electronically by exchange of signature pages and executing and delivering those via email. Finally, other closing items are obviously the payment of the purchase price or a portion thereof if if the agreement has set forth installments. Transaction expenses will be apportioned and paid. And then the membership interests or stock or the assets of the company are officially transferred. There are other items that go into a closing, that may be is individualized to the particular agreement, but generally these are some of the items that will be included in almost any closing.